All rise. The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Good afternoon, everybody. Can you hear me okay? I think so. Great. I am Judge Lucy Inman, and presiding with me this afternoon on my right is Judge John Arrowwood. On my left is Judge Darren Jackson. And it's really special to be having a session of oral argument at this law school for all three of us. We're very, very grateful to be here, and we're looking forward to hearing these oral arguments. We have two cases on the docket this afternoon. The first case is State v. Acker. This is number 21-512 from Craven County. And counsel, are you ready?
I'm ready.
Very well.
The Masks Honor Office is speak.
So what I understood from the dean of this law school is that the university requires masks in all classes. And we figured when in Rome, do as the Romans do. If we can't understand you, I'm gonna let you know that. And if you can't understand us, let us know that. That would be the only exception that I would make. And obviously this case is important to your client. So
Thank you. May it please the court. I'm Michael Castorline from Asheville, North Carolina. I'm here on behalf of the appellant, Jeffrey Acker. I would like to reserve 8 minutes for rebuttal in this argument. We've got one issue to address.
before you start, normally I'm kind of spoiled because I'm at the Court of Appeals and we have someone else keeping time. And I don't even have my phone.
You're all right, got time.
You've got time. Perfect. Thank you. Thank you.
Thank you.
Very well. Sorry about that, Mr. Castellano. I just wanted to make sure you
The first issue, before I get into the facts of this case too much, we brought forth one issue. It's about the failure of the trial court to give an instruction on perfect or imperfect self-defense or manslaughter. But before I get to that, I'd like to talk about the standard of review that is appropriate in this case. Now, in my brief, I argued this as a plain error issue, and I think the state acknowledged that I made that assertion that it's plain error. Upon reflection, after the state filed their brief and doing some additional research, and I mentioned this in our reply brief, it may be reviewable under a de novo standard of review. And what happened in this case is that the defense—
How is it reviewable under the de novo standard of review?
Well,
in this case?
I think it depends on how we characterize what happened during the charge conference.
Can you first explain, when you wrote your opening brief, why you argued plain error review?
Well, it goes to exactly what happened. Here, defense lawyer files a written notice of self-defense, files a written request for those jury instructions, makes his pitch at the charge conference. Trial judge says how he's going to rule on that. And then before the jury is instructed, he says, we consent or we assent to those instructions. And so it's not a situation where we would have more like the State v. Smith or those line of cases where we're talking about the failure to renew the objection after the charge is given.
It's actually worse than that, right?
It's actually, it almost is worse than that. And I think that's probably why when I wrote the brief initially, I'm thinking this has got to be plain error, and that's the way I wrote it.
Because even if under there's a whole line of cases that even if when the judge is given the jury instruction and asks counsel, are there any objections or corrections or additions? And they say no. There's a whole line of cases that say that you waived your objection at that time, isn't there?
Well, there is, but there's also a line of cases that says that under State v. Smith, and I think I cite these in the reply brief, that says it's not incumbent upon a defendant to renew their objection. And I guess it goes to how, sometimes I've seen defense counsel or say, no, except for what we've said before, or nothing gets said. But in any event, I think the appropriate standard of review and the two things I want to say as I've contemplated this issue are, I try to imagine what is the case where a defendant would prevail under de novo review, but lose under plain error review when we're talking about a murder trial where somebody is facing, a staggering sentence. What is that case that we say, well, this is a mistake, but not enough of a mistake to constitute, the standard of plain error. And that's one of the things that when I ponder this case, I say, well, what will we say that he should have given the instruction, but the failure to give it didn't impact the fundamental fairness of the trial, or the failure to give the instruction doesn't rise to the level of plain error, but would have been error under the other thing. And I think that at this point, depending on how you evaluate, it may be characterized as even worse. The judge has made his statement, and the trial counsel for the defendant does, manifest an agreement. We can't argue that he didn't say that. He clearly says that. So I think that this court, in reviewing this case, has got to determine on those facts. I couldn't find a case directly on point where the consent or the agreement with the instruction is given so clearly and so explicitly before the instruction is given. But nonetheless, arguing it as plain error or arguing that the instruction should have been given, I think that on this case, the defendant has established a prima facie case that would warrant a self-defense instruction. And let me just talk briefly about the facts of this case. We have an enmeshed relationship between the decedent, Carolyn Patterson, and Mr. Acker's family, where Miss Patterson had been caring for since he was an infant, my client's nephew. Not placed there in any legal custody, but placed there by my client's brother, who did have legal custody, and she had raised this child and had a very, mother-son relationship with him, despite, she's an older woman. But also the family had known each other for a long time. My client's parents lived on her property. My client has known this woman since he was a child himself. And they have a very enmeshed relationship. Now, during the summer of 2018, tensions were getting hot between the family because the mother of that child, I think we refer to him as Brian, pseudonym, had believed that Department of Social Services was going to take the child from Miss Patterson and place the child with her. And it's based upon this encounter that happened on the day of orientation for school, and then later in that evening, where my client assaulted and killed the decedent. Now we get to the event in question, and I think the state's contention is that Mr. Acker, through his testimony, has not established a prima facie case, not introduced sufficient evidence to establish or to warrant a self-defense instruction. And I think clearly this is a situation where he's testified to all of the elements necessary, to the subjective belief, to the objective belief, and to the intentionality of his act.
Well, now, Mr. Castelline, your client, and I believe all these statements came in, and you haven't raised that they should not have come in. Isn't it also a fact that your client told numerous people that he killed this woman and that he hit her and beat her over the head with the baseball bat, and that he even left a note on the table apologizing or talking about it in her house. And not once until he got on the stand did he talk anything about, I saw something that might have been a black object in her hand.
Well, that is very true. And that is exactly the kind of factual determination we trust and rely for the entire history of our state juries to determine.
But
And
did he ever testify that he was in fear of his life when he hit her?
he testifies repeatedly about his fear and her apprehension and that she may have had a weapon. And
But didn't he also testify that he hit her in the back of the head and he only hit her in the back of the head once?
well, he doesn't say, I only hit her once. He says, after I hit her, I don't remember what happened after that. And so
But he
we
hit her
have,
in the back of the head. He testified, even the testimony where he says he thought he might have seen a black object in her hand, that he hit her in the back of the head. Did he not?
yes, but I don't think that the fact of, we have cases, and I think Spalding is probably the best one, talking about apparent necessity. And again, even if it's imperfect self-defense, it would then warrant the manslaughter instruction, which may have been, a jury may have found that in this case. The jury was instructed on first degree, found second degree. We have a situation where they could have found from his testimony. And I think really what troubles me the most about this case is that after the defendant testifies, and he testifies, and you may be skeptical about his credibility, that the judge, rather than doing any of the type of analysis that the state has so ably done in their brief about his testimony was vague about fear, he doesn't testify to an intentional act, and those type of things, the judge isn't doing any of that analysis. The judge is making a cynical assessment of his credibility. Purely, he says that's a fantasy.
Well, but if the judge is correct, if the judge's ruling is correct on all the reasons the state says, does he get a new trial because the judge may have had another reason in the back of his mind?
Well, I believe that under plain error, and remember we have two prongs to plain error. We have the it would have made a difference prong, and then we have the fundamental fairness prong, or a ruling that impacts the fundamental fairness of a trial.
Well, we also have the prong that if the evidence is such that it wouldn't have made a difference, that you've got to overcome in plain error too.
Well,
doesn't that go to the subjective amount of what we are supposed to review, including all the testimony, that it wouldn't have made a difference?
well, in terms of, it's my belief that if we want to have faith in juries and have juries make these factual determinations, that it offends our notion of fairness to have judges just make a cynical assessment of credibility and then deny an instruction. We trust juries. We have, I think I cite a case from 1870 talking about the peculiar province of the jury to assess the facts because they're there, and we trust those juries to do that. And
Can I just ask you a question, sort of a little open-ended? You do acknowledge that one of the prongs you have to show is that not just that it might have made a difference, but the jury probably would have reached a different result if this instruction had been given, right?
Well,
do you disagree that that's the standard?
I believe that plain error actually has an alternative standard of a rule. It says, I think we cite this in our reply brief in the brief at the beginning, that you must show either that it would have made a difference, or and this is the alternative standard, plain error consists of an error so fundamental that it undermines the fairness of the trial, or that it impacts the jury. So I think that those are
So you believe that
alternatives.
those are alternatives, okay?
I believe those
Can
are
you
alternatives.
Give us your best synopsis of what Judge Arrowood has recounted from the evidence is a woman is found dead, her brain matter is spattered about her mobile home. She's been hit with a baseball bat. I think her body's lying on top of the baseball bat. There's no gun found anywhere in the scene, no black weapon found anywhere on the scene. What is found is a note that your client wrote, acknowledging that he had done this, but doesn't remember what happened afterwards. And then Mr. Acker goes to get a sandwich, encounters some people. They notice there's blood on his clothes. He says that he killed this woman. He goes to a bar, I think, and says that he killed this woman. He tells one person that he killed her because she was talking about his family. So that's sort of the highlights, I guess, of the state's evidence. Can you please tell us what reasonable inferences a jury could draw from what he testified at trial that could lead them to think that he acted in self-defense?
I think that what we would have, the best facts that we would have, if and taken again in the light most favorable, assuming the jury believes every one of them and believes them strongly, I guess that's what that means, that one, she had a special relationship with this child and she was afraid of losing the child. And it would not be uncommon at all for somebody to be motivated, strongly motivated, to protect their relationship with their child. She had that. He believed she had a weapon. In apparent necessity, there's abundant cases on that. Believed she had a deadly weapon and he believed it. He may have been wrong, but he believed it. Number two, her rage that he testified to, that she was raging, she wasn't herself, he'd never seen her behave that way, her in the moment. And finally, the idea that he had not known her to act that way. There was something dark in her. So I think we have a motive, a strong motive by her to want to perhaps be threatening and threaten the family. And then we have this milieu, this kind of backstory of the tension between the families that goes back for some period of time. Now, if the jury believed all of that in the light most favorable, they could have found manslaughter. They could have said he shouldn't have used, he used excessive force, imperfect self-defense, but at the moment that he acted, his belief was reasonable. And
Well,
that's-
so he hit her from behind, even though he hit her from
Well,
behind?
even if apparent necessity, again, I think is that he believes in the moment. If you think somebody has a gun and they've turned away for a moment, maybe that's when you hit that. I think that, again, to me, it comes down to the faith that we have in juries.
Well,
And
but correct me if I'm wrong, didn't he initially testify, I thought when I was there, the first time I saw her with some black object in her hand, and that he went away, and then he came back again, and then he hit her?
yeah, then the final tense altercation definitely happened on the second time, but he didn't enter the home armed. He wasn't one of these people, I think, maybe the Spalding case where somebody went back to an encounter with a weapon. He didn't go back there with the weapon. The weapon was there. And that's where he says, she's raging, she's throwing things, she's behaving in a violent manner, raging, and was not herself. And again, you know, the intent that we trust juries with, you know, we let facts go to a jury because intent is seldom provable by direct evidence. We let juries make inferences. And we can talk about the things that don't line up and are incongruous, but that's exactly what I contend is the peculiar province of the jury, is to make those determinations. And when we just don't read the instruction, the 2 or 3 paragraphs of that instruction to give the jury the option to do that after defense counsel has given notice, after defense counsel has put forth what I would contend is a coherent theory.
But then defense counsel has said, Your Honor, I consent to this jury charge going forward without this instruction in it. So we also have defense counsel saying this is okay. Is that not some indication that it's not fundamentally unfair?
Well, it could be it could be a manner of the defense counsel speaking and being polite and deferential to the court. That's why I think it's important for us to have a plain error standard and to look at the evidence and look at, I mean, this is a case where if we want to say the prima facie case was made for self-defense and the trial judge makes this, again, what I would contend is a very cynical assessment of credibility. It's a fantasy. And you know, that's I thought about, you know, is that a comment on the evidence of something? It's a fantasy. It's not, the trial judge isn't saying, well, he was vague about this, or he didn't testify to his intentional act or his memory. He's not saying any of that. He's saying very cynically, very much an assessment purely of the defendant's credibility. It's a fantasy.
And is that a separate basis for your appeal? What
The
the trial court said?
well, I think it just demonstrates that he isn't.
Because you haven't raised that, right, as a separate.
No, I'm just.
We've seen cases in which comment by the trial court on the evidence was the basis for an appeal.
Yes.
But that's not what you are.
No, he didn't make that in front of the jury. He made that comment during the charge conference.
Right.
But I would contend that it's nothing more than an assessment of credibility and not applying what is the appropriate legal standard, which is looking at that evidence in the light most favorable to the defendant. That means, you know, assuming a jury is going to believe every part of that, believe that she was raging, believe that she had a weapon, or that Mr. Acker thought she had a weapon, believe that she was perhaps motivated because of this relationship with the child. This isn't just saying he went over there one night and it was just like every other night. She's arguing that she feels the most precious relationship in her life is threatened. And they demonstrated that not merely from Mr. Acker's testimony, but from the testimony of other witnesses.
But it wasn't threatened by him, was it? It wasn't threatened by, he wasn't the person threatening it.
No, he wasn't the person threatening it, but he was among the family that was threatening it. And I think there was a lot of evidence that he was kind of sometimes the intermediary between her, Miss Patterson, and Miss Tripp and Miss Patterson and Acker's parents, who had the other nephew of the child. But in any event, we think that
You have 1 minute
Yeah.
before this is time. One question that and forgive me if I missed this in this record. Did Mr. Acker raise any defense of diminished capacity?
there was notice of that, and there was talk about that in the trial, but it isn't anything that we've raised our appeal. And I think there was, I don't even recall right now if there was a voluntary intoxication instruction given, but I know there was discussion of that. And there is in the record on appeal a notice about that. But that's all I have. If I have any time left for rebuttal, thanks.
Thank you.
May it please the court. Good afternoon, your honors. I'm Michael Wood with the State Department of Justice, representing the state in this matter. Thank you for the opportunity to come to this wonderful law school for these hearings today. I killed her because she was going to kick out my parents. She was going to turn the lights off to the trailer. I was tired of her ass. Anyone ever pissed you off enough to kill them? She done pushed the button. I was seeking retribution, but I don't have remorse because I caught her unaware and she never saw it coming. I hit her when she wasn't looking, so it probably hurt less. That's the context of this case. Those are words in the record from defendant's mouth in this case. At the same time, he's contending that the trial court made an error by failing to instruct on self-defense.
Well, but his testimony at trial, this is all on the record, and I agree, and I asked Mr. Castelline about it, but those are all from contemporary statements that he made to people and got introduced through body camera or something like that. At trial, he did testify, did he not, that I saw her with a black object in her hand, and that I was fearful, and that I killed her. Doesn't that raise at least a prima facie case, taking the evidence in the light most favorable to the defendant, as to why at least this instruction should have been given for the jury to make that determination?
I have two answers, Judge Arrowood. So number one, yes, I think we need to make a distinction between what defendant testified to at trial. And I agree that needs to be looked at for his subjective beliefs, and not, it would have been improper for the trial court or for this court to resolve that evidence. If there's a conflict, I agree that that had to be given in the light most favorable to defendant. So yes, however, all of those statements absolutely go to the plain error standard of review and to the defendant's burden to prove that there would have been a probable different jury verdict, but for the omission of this instruction.
Can you speak to the standard of review and the prongs of the standard of review
Yes.
that Mr. Castelline addressed,
Yes.
and whether you agree with him or disagree with him and why?
Yes. So the state certainly maintains that the plain error standard of review is appropriate here, Your Honors. First of all, defendant conceded that in the opening brief, and while they tried to walk that back a little bit in the reply brief, I don't think it's appropriate or common to ride a new horse and come up with a new theory in a reply brief. So procedurally, we believe plain error is the right standard. Secondly, not just once, but twice on the record, the trial judge turned to defense counsel. Once was right after the charge conference as the jury instructions were finished and before they were presented to the jury. The trial judge said, "Are you good with this? Is there anything I left out?" And defense counsel said, "No, Your Honor, I'm good with it." And that's at transcript 846. And that was cited in my brief. But again, a second time, after the trial judge fully instructed the jury and did not include self-defense or manslaughter, again, the trial judge turned to both sides and said, "Is there anything that I omitted, anything that you wanted to say in addition, Your counsel?" And that's at transcript page 937. And again, defense counsel said, "No, Your Honor, we're good." So two times when he had the opportunity to preserve his objection, were to remind the court that I had submitted a request that Your Honor has previously denied, and we still have that preserved for appeal. Two times defense counsel assented and waived. So we don't think it's a close call, Your Honor. We think this is the plain error standard review would be appropriate here. I do agree with Mr. Castelline that I think it's a disjunctive test, and the plain error standard, to my understanding, is that the defendant can either show a fundamental error that rises to the level of miscarriage of justice, or that there was a probable impact upon the jury verdict. I agree. I'm not sure how you could have one without the other necessarily, but I do agree, and I believe the law supports it. It's a disjunctive test. And of course, here the state's position is, based on all of the statements and all the other physical evidence in the record that I'll talk about in a moment, defendant can't, even if it were the lower standard of harmless error, we don't think the defendant could meet that standard. We certainly don't think defendant can meet the probable impact upon the jury standard against this mountain of state evidence.
So you would say that if defense counsel had said, "No, Your Honor, I'm not okay with that. I'm taking exception to your denial of our request for self-defense instruction, and I'll go to appeal on that basis." And if we were here and you were arguing this case, you would argue there was not prejudicial error, much less plain error.
Correct, Your Honor. The state's position would be there was no error. If there was an error, that it did not impact the jury verdict in this case. Yes, Your Honor.
Well, could you tell us, you've said a couple of times that there was no error, can you, and that if we look, can you tell us why the state believes that he wasn't entitled to this instruction in the first place?
Absolutely, Your Honor. So the test isn't, was there any evidence to support a claim of self-defense? Our Supreme Court has never said the test is there any evidence? And whenever there's any evidence whatsoever, there is a duty to instruct on self-defense. To the contrary, the standard is, was there competent evidence? And the legal standards are quite clear, and the parties agree on it, I believe, that the determination of whether there was competent evidence is a gatekeeping function upon the trial court. And there's the subjective and objective standard to determine whether the evidence was competent.
Well, but doesn't competent talk about it, go through admissibility as opposed to weight?
I don't know that I've read the case law that way, Your Honor. If the judge is looking to what is the defendant saying in support, is there really evidence that the defendant truly believed he had no duty, no option but to kill?
But the judge can't say, I don't believe what he's saying, and therefore it's not competent, can he? You're not arguing that, surely.
I'm surely not, Your Honor. That's right. No, so it's not a question of weighing determination. It's certainly not appropriate for the trial judge to be looking to resolve conflicts in evidence. I think if the trial judge had done that or had made a determination on credibility, that would have been improper, and that could be error.
Well, Mr. Castelline has just talked about him saying it's fantasy, so why isn't that way?
So that's an interesting phrase, the fantasy, right? I submit that I think the judge knew the standard of review right before he used that word about, I believe that the defendant's testimony is fantasy. There had been a colloquy with counsel, and they had reminded the judge there's a subjective standard of review and an objective standard of review. And so to me, the way that context of that comment on fantasy reads is the court correctly was exercising his gatekeeping function. He was looking at the words from defendant's mouth without having to resolve it, without having to believe him or disbelieve him. The words alone from defendant's mouth undermine his claim of self-defense.
And can you point us to those words that you say
Yes.
make that he's not entitled to a self-defense?
Yes. There's a couple points there, Your Honor. Probably the state's best showing is the defendant's testimony about where and how he hit Miss Patterson in the skull. There's no explicit testimony from the defendant that he was in fear for his life, of an imminent risk of death, and had no choice but to kill her. But he's very explicit, in contrast, when he talks about hitting her in the side of the head. And right on transcript 804, he says that she was turning away from him. He saw the profile of her side. He hit her with the bat on the side of the head. So this isn't somebody who's coming towards him. This isn't an imminent threat with a lady with a gun heading towards him in a way that put him in jeopardy. By his own words, she's turning away from him to the point that she's not facing him any longer. That's when he hit her. That's when he hit the side. He saw her side profile. He hit her from the back as she was turning around. I think that testimony is directly contrary to any suggestion of self-defense. You can't be in imminent fear. You can't be worried that this lady is about to come at you when she's turning away from you. And that's when you hit her. And for what it's worth, Your Honor, I agree, we only look at defendant's testimony when we're determining his subjective belief. But his own words that she was turning away and he hit her in the side of the skull with the baseball bat is corroborated in a couple of ways. Number one, the medical examiner said, yes, Ms. Patterson was hit only in the side and only in the back of the skull, not in the front. So we don't need to resolve a conflict to see that defendant was telling the truth when he said he hit her on the side of the head. And secondly, later when he was being arrested, as I've already said, the defendant repeated a few times that he hit her from the side and that he was proud of himself for doing that because it probably hurt less because she didn't see it coming. Again, we don't need to resolve any conflicts there. The two pieces of evidence I just said are entirely consistent with defendant's own words of hitting her in the side of the head, seeing her profile when he did so. I think that negates any claim of self-defense. In addition to that testimony, there's a bunch of other factors in his own testimony that I think negate any suggestion of self-defense. For one, I think I counted 7 times in his direct testimony, he said he was fuzzy about that night. He didn't remember the details. In fact, he blacked out and didn't come to again until 24 hours later at the Tiki Bar at the Oriental Marina. And of course, Your Honor, if he can't remember what happened, then he can't establish intent to save his own life by the only means necessary, which is the use of deadly force. So yes, he gets every inference. Yes, the court is to view the evidence in the light most favorable to the defendant. But, you know, in some ways he wants his cake, he's having his cake and eating it too, by only remembering certain parts of what happened that night and either genuinely or not genuinely not remembering other key details. To be sure, he does use the words, "I was afraid." And he did use the words, "I was scared." But he's kind of nebulous about that. Remember, at one point he said he was afraid that Carolyn Patterson would kill herself. So that's not fear for himself, that's fear for her doing self-harm. And that was in connection with the first time he came over to her trailer and thought he saw a black object, thought that it might have been a gun, didn't bother to tell anybody, didn't tell his mom and dad that my next door neighbor might have a gun, but had this idea that maybe she would hurt himself or maybe she would hurt someone else. And of course, there's a Lyons line of cases that's cited in the state's brief around pages 16 and 17, which says uncorroborated testimony from a defendant of fear, standing alone, is not the same as saying, I was in fear for my life, I was in fear of imminent harm, I had no choice, but for necessity, I had to kill this person. He said he was scared, he said he was afraid, but he didn't ever get as explicit as he did about the hitting of the skull. There's no explicit testimony of necessity in this record, taking his own words and even taking them in the light most favorable to him. I'll also say a comment about defense is trying to characterize the trial judge's comment about a fantasy as a cynical assessment by the judge of his credibility. Again, not to repeat myself, but I don't think that's the only way that can be read. I think the judge looked at the subjective and objective test and said, in fact, they referenced that the medical examiner confirmed that she had been hit in the side of the skull. That was important to the judge right at the same time he was making his comment and his decision to not instruct on self-defense. So all I've talked about so far, Your Honors, is the subjective part of the test. Of course, don't forget there's also the second part of this test, which defendant cannot meet. And that second part is the objective test. What would a reasonable person of ordinary firmness have believed at this time? And there's quite a lot here to show that even if the defendant truly genuinely believed he had no choice but to use deadly force, that is just not a reasonable conclusion for a reasonable person to have made. We can talk about the long-term family relationship, right? Defendant testified that he had known Carolyn Patterson for almost his whole life. He was close to her, he had slept in her trailer. She had been a family benefactor, not only to defendant, but to his nephew, Brian, to the rest of the family by giving money and clothing and care for years and years. It's just not objectively reasonable to think that your family benefactor suddenly one day invites you into her trailer, pulls out a chair so that you can have a conversation with a secret plan in mind to take a gun and murder you. It's not reasonable for him to have reached that conclusion. Your Honor asked a question that I was going to emphasize, Judge Earwood, which is, even if she was irate and taking his testimony as true, that she was out of her mind with anger, a darkness in her eyes, she was furious because DSS was going to remove Brian from her and award to the birth mother. Even taking all that as true, it still doesn't explain why Carolyn Patterson would have been angry at defendant. It wasn't defendant's child. He's an uncle to the nephew. His mother, defendant's mother, testified there was really no relationship between defendant and Brian. He was sort of irrelevant to the custody battle. So objectively, again, it doesn't make sense for, even if he had the actual belief that he was in peril, it doesn't make sense that she would be angry at him, angry enough to murder him. There's also physical factors. This is a little room, a 9 by 9.5 computer room in a trailer. She's in the room by his testimony, and he's in the hallway by the door. So if he's truly in fear of his life, if he truly sees a black object that's a gun, all he has to do is take a half step backwards and turn and run, and he's gone. He's a younger man, physically fit, 5'7" guy. I think he was 178 pounds. She's a 68-year-old woman in a boot with fibromyalgia. She is not going to chase him down and chase him out the hall and down the stairs and into the yard. It's just not objectively reasonable for him to have concluded he had no choice, that his only option was to take a baseball bat and bludgeon her. And last point on the objective test, Your Honors, what would a reasonable person do after encountering perhaps the worst thing that could happen in your life, which is you have to kill somebody to save your own life in your own self-defense? He didn't call the police right away, not that night. He didn't tell anybody from his own testimony. Instead, defendant went home, kissed his mother goodnight, and slept on her couch in his bloody clothes. And the next morning, he still didn't tell anybody. He woke up and went back to Carolyn Patterson's trailer and left that note, the note that says, I'm summarizing, I don't remember any of this. It's still vague, however, insane with a cause. Again, Your Honor, none of that is objectively reasonable. The note saying insane with a cause is dramatically contradicts any suggestion of self-defense. For all of these reasons, Your Honor, I think the trial court correctly understood there was a subjective and an objective test and correctly made the determination there wasn't competent evidence for this issue to reach the jury. And my last point, Your Honor, is
Mr. Wood, I want to ask you a question
Yes, sir.
about that. This is hypothetical, and so I'm going to ask you to assume that the defendant had not left that note, and assume that the defendant had not made these out of court these statements at the bar, whatever. Was his trial testimony enough to get him that type of instruction? If you just look at his trial testimony and don't get into the weighing and the credibility, but just his testimony, was that enough?
the answer from the state would be no, Your Honor. And again, I don't, all those other facts, all those other admissions are important in the context of the case, but take that out of it. If we just focus on his, his 70 pages of testimony, again, his point that he hit her as she was turning, hit her in the side or back of the head. And I think that right there, without anything else, negates A, that there was an imminent threat for which he had no choice but to defend himself. And B, it negates the intent to self-defend. So those words are really important. There's also some testimony that was in my brief about the prosecutor said to him, did you actually intend to kill her? And he kind of equivocates and said, no, I would never intend to kill her. Again, that's not an affirmative statement that he intended, that he had no choice. It doesn't support necessity to use deadly force to repel a deadly, what he thought was a deadly attack.
Does Judge Erwood's question earlier about that he claimed to have seen a black object in her hand the first time, but didn't make that claim the second time, is that relevant in your analysis in any way?
If I may correct, Your Honor, he did think he saw a black object that he thought might have been a gun the first time he went over.
Right.
And then he retreated to his house, sat on the swing, and came back. He also did say, initially she did not have a gun, I did not see a gun, but when I got to the computer room, when she started yelling, I thought I did see a gun again. So in the record, I think he does say a second time in the computer room, he perceived a black object. And your question was, is that relevant?
Yeah, I'm just wondering, if someone is claiming that they have a subjective belief that their life is threatened or in danger, they see a black item in someone's hand and they leave, and then they come back unarmed. Does that change did they really have a subjective belief that the person had a gun and they left and came back, didn't bring a gun themselves, or some other type of self-defense?
It's curious that he suspected that she might have a gun to either hurt herself or someone else, and yet, went back and put himself into that position again. It does undermine his suggestion that he thought there was an actual gun there. And of course, no gun was found at the scene, so we know that there was not a gun. Bringing me to my final point, Your Honor, we believe the defendant cannot meet his burden because the state's evidence is overwhelming. He cannot show a probable impact on the jury's verdict for all the reasons that I have stated. We don't even need to look just to the defendant's words, of which there are plenty, of which I just read a subset when I started today. We can also look to the physical evidence. The medical examiner, Dr. Acker, testified that there wasn't just one hit to the skull. There were so many skull fractures that there were too many to count. But she could say there were at least 3 impacts to the skull. And SBI agent Laura Kensington, who's the crime scene investigator, she also testified to the physical evidence and described in some great detail this very bloody, violent crime scene in the computer room. And she said that the blood spatter pattern was clear to her that Mrs. Patterson must have been hit as she was falling and near to the ground. Again, that is inconsistent with the idea of self-defense and necessity. That is, if you're going to hit somebody to defend yourself, you're not likely to hit her as she's still falling to the ground. You're not likely to do that much skull damage. And last, Your Honor, there's also evidence in the record put on by the state that the defendant tried to flee the scene. As the police tried to apprehend him after he called 911 on himself, defendant didn't cooperate. He didn't submit and say, I have something to tell you, I had to do this in self-defense. He fought quite a few times, quite a bit violently as they were putting him in the cruiser, as they were moving him to the jail, and later as they were moving him out of the jail. All of that can be read by the jury as evidence of a guilty mind under the case law cited in our brief. For all those reasons, Your Honor, we submit that there was no trial court error. We submit that this court should dismiss this appeal. Thank you.
Thank you very much.
I have 2 moments left. Thank you. Your Honor, again, I think that we can pick and choose and try to weigh the evidence and spin it. But again, I think that that's when we start to invade the province of the jury. And remember, what we're talking about here, I think that the state wants to characterize this almost as a magic words test, like the defendant has to say very precise things. I was afraid for my life, and therefore I felt it necessary to use deadly force. And it's not that at all. It's never been that. We are entitled to all reasonable inferences from the evidence. I was afraid, and I thought she had a gun, would seem to warrant an instruction on perfect and imperfect self-defense, even if we believe he didn't strike her at the right time, struck her as she looked away. But those words there alone would seem to warrant
Now, is there any
the apparent
case where
necessity.
we have said that if you say that they had a gun at some point and I was afraid for my life, that gets you a self-defense instruction?
Well, there are not cases where there have been cases where someone has been denied an instruction on saying those type of things, where somebody has had a weapon. There are cases that I want to say Harvey, but I may be wrong about that site. I think the weapon in Harvey might have been different than a gun, but there are cases that seem to suggest that doesn't alone get it. I would contend that the overwhelming number of cases are that follow the language, I believe, from Spalding, is this apparent necessity idea that if you believe somebody has a gun, that a deadly weapon, and again, a deadly weapon coupled with her motive. On the first time she was there, he thought he might have saw the gun, but she wasn't raging. He didn't testify to that. He testified, I think, something along the lines of things change. And again, the motivation that she might have against him, he was the conduit for the information about Brian. He was the messenger that was bringing the information that, hey, they might take Brian away from you. That's why she may have flown into a rage that evening. And again, all reasonable inferences from the evidence, not merely this magic words test. And when I look at this case, and the state wants to line up all of the things that are incongruous or suggest that self-defense, and I think of all of the abundant cases where, as an appellant, we're arguing that, hey, they shouldn't have submitted first-degree murder, or they shouldn't have submitted this because there was all this inconsistent evidence. And I think we cite the inconsistencies. If there's evidence that contradicts something, that is again a question for the jury. And what we have is no question there's a lot of inconsistent things he said. But again, weighing it, and I think as Judge Jackson said, would his testimony alone have warranted a self-defense instruction, looking at what he testified to, and about what, and that's asking the jury to decide what he believed in that moment in the light most favorable to the defendant, not how he acted afterwards when he was afraid, not where he went and what he did afterwards, but in that moment, did he think she was raging, she had a weapon, she's mad at my family, and I hit her. And I think those facts warrant a self-defense instruction. It was plain error for this court not to give the instruction. And I think that the only other thing I would say is that those facts don't come just from the defendant's words. They come from also the testimony of other witnesses establishing this friction between the families in this relationship. I think the testimony about the gun comes actually from a state's witness that she was known to own a gun. It's not entirely based upon his self-serving testimony. It's based upon the entire record. And I think that there was evidence, again, giving him the benefit of all reasonable inferences and not holding him to this magic word standard. He gets that. I think actually as much as he says he's fuzzy, he also at one point qualifies that his memory lapse begins after he struck the first blow, basically. I don't remember anything after that, is what he says. I think that's on page 775 of the transcript, until I woke up in the tiki bar in Oriental Beach the next day. But unless there's any other further questions, I think that's all I have.
One, just,
Yes.
pardon me for not remembering just from his testimony. Did he explain why he wrote in that note insane with a cause?
He testifies, I believe what he says is I don't remember writing it, but I must have written it because it's my writing. So he doesn't offer an explanation of what he meant. And I think that that's his testimony.
Thank you. Thank you so much for your excellent arguments, counsel. This case is submitted.
Thank you very much.
And we'll just be at ease for a few minutes while counsel change out.